Court's now in session. You may be seated.
SJC-11266, NES rentals, and relevant law.
All right, let's proceed.
Thank you. Good morning. May it please the court, John Ferreter for the appellant, Maine Drilling and Blasting. This is a Chapter 254 mechanics lien case involving a developer by the name of Berkshire Wind, a contractor by the name of Maine Drilling, a subcontractor by the name of McManus Construction, a second-tier sub by the name of NES. NES, the appellee, was not paid by the first-tier subcontractor, McManus Construction, and so McManus, strike that, NES timely perfected a mechanics lien against the property owner, Berkshire Wind, and in turn, Maine Drilling timely substituted a bond for that mechanics lien.
In the interim, something happened. There was litigation.
There was litigation.
So the lien was perfected.
Yes.
And then NES brought a suit.
Well, Berkshire Wind was sued
Right.
as the landowner, correct.
Right. So there was a suit on the lien.
There was a suit on the lien.
And then your client, or I'm sorry, who came in and substituted?
Maine Drilling
Maine Drilling.
was, because the bond came in place, and the bond essentially substituted for the lien, and that we'll get into later on.
Weren't you sort of essentially automatically substituted for the defendant in the case?
Not automatically.
Well, okay, but if an amendment were allowed, you would be subject nunc pro tunc?
Not necessarily. According to the statute, the suit on the bond, so not a suit on the lien, the suit on the lien was brought within the proper period of time. Mm-hmm. But under Section 14, the suit on the bond must be commenced within 90 days after notice is provided of the bond. So we're in agreement that, and in their motion to add Maine Drilling as a defendant, their motion to amend, which was allowed by the trial court, it's agreed that on June 11th was the date that notice was provided to NES that the bond was being substituted for the lien.
And you were the party that substituted the bond for the lien?
Yes.
Why, I don't know much about this area. Why does one do that?
Well, because there's a contractual relationship between a contractor and a landowner. If you're a smart landowner, you don't want a lien on your property, so you put the burden on your contractor, which is my client, to substitute a bond, remove the lien,
I see.
and then title is clear to the property, and the bond, which is in place now and has been in place since June 11th, and notice my brother acknowledges that the bond was properly recorded in the Registry of Deeds, acknowledged in his motion to add us as a defendant that notice was properly given on June 11th. So that's when the clock started ticking for the 90 days.
And the motion to amend wasn't itself filed until October 2nd, is that right?
That's correct. That's correct. It was served under 9A, and that's what the trial court said. Essentially, and our argument in the brief is that the trial court substituted the word provide notice for the requirement in the statute, Section 14, which says that you have to commence suit. And under the rules of civil procedure, you don't actually commence a suit until you file a complaint. And so that's our argument, is that they were late, and that Chapter 254, the mechanics lien law, is full. Every single section has a deadline, and if you don't meet a deadline, you don't have your lien. And in this case, the bond was substituted for the lien, so there's still strict construction of those deadlines. There's the plain meaning of the statute, which says you have to commence an action. Essentially, nothing happened between June 13th in 2011 and the service under 9A didn't happen until August 23rd. So one of the arguments that NES makes is, well, this is not our fault, it's Rule 9A's fault. Well, Rule 9A has been in place for 24 years. We've all lived with it, whether we like it or not, and you have to plan ahead. You have to plan ahead under Rule 9A. And Rule 9A also has emergency.
But the difference, though, is that if you were simply to initiate a complaint, there's no 9A obligation. You just file the complaint and you serve.
That's one of our arguments, Your Honor.
But where there is a complaint, you do have to, if you're going to be moving to amend to add a party, you do have to follow 9A.
That's correct. But there are options.
And so why is the first step in adding a party not the commencement of a civil action under the statute?
Well, because under, let's see, under the rules of civil procedure, I think it's Rule 3, says the commencement of an action is either by filing in the clerk's office or by serving by certified mail on the other side a copy of the complaint. Neither one of those occurred within the deadline.
But that's speaking of the initiation of a complaint. It doesn't speak about adding a party through a motion to amend.
But under the statute, when you're dealing with a bond, specifically Section 14 is talking about bonds, and it says when you want to add a party, you have to commence an action. So one very easy argument is that NES had a decision tree here. Either move to amend and have to deal with 9A, have to deal with the possibility of an opposition to amend the complaint, which ultimately happened, had to deal with other delays of the court, which naturally happened, or the other option is, if you're worried about a 90-day deadline and you're bringing in a new party on a bond, you file a new complaint.
But why is that sensible for us? Doesn't it make more sense for there to be one case than two? I mean, then you'd have to have two cases, and then you'd have to move to consolidate. Why should we interpret the statute to complicate the life of the Superior Court?
Well, I don't think it does. Ultimately, in this case, Berkshire Wind brings a motion to dismiss and is out because the bond replaces the lien. Berkshire Wind is no longer part of the case. So it doesn't complicate because that old case is now gone. Berkshire Wind is out. That case is put into archives, and you have a new case involving the bond itself. So I don't think it complicates the life of the Superior Court. But the other option is when you get notice on June 13th that there's been a bond, you file your motion right away. Or if something happens and there starts to be some delay, then under 9A, you file an emergency motion to add a party. If there's a 90-day deadline to commence an action against Maine Drilling, you do everything within your power to commence that action against Maine Drilling within that 90 days. You don't wait. You don't do other things. You take every reasonable action, which I think the record shows was not taken, and certainly one reasonable action would be to file another complaint.
If they had filed the 9A package within the 90-day period, wouldn't your argument be harder?
A little bit, but I still don't think...
Because we've had other cases where we've said that the commencement of an action is when the motion to amend is served.
Yes, and in this case, that was not done. The deadline was September 11th, and the 9A package was not served until after that,
because,
in this case.
You know, I think some of the considerations are that, you know, it's really out of your control once it's in the hands of the court. That was certainly Judge Sossman's reasoning in the Net case.
You mean served or filed?
well, I'm sorry, filing of the motion to, filing of the motion to,
Filing
amend, I'm
of the
sorry.
9A package.
Yeah, filing of the 9A package, puts it with the court. I mean, the party doesn't really have control of when the judge is going to act on these motions.
Yes, it's out of council's hands at that point.
But that happened in October, is that right?
That happened
That just-
after the September
Right.
deadline. It happened in October. So yes, that did not even happen here. So I think that there are a whole lot of things that we do agree on, and that's that the actual action was commenced late, that the deadline, we agree, and the trial court agrees, was September 11th, that the package was filed on October 3rd. We agree that NES could have filed a new complaint. We agree that they could have filed an emergency motion under 9A. And we agree that NES cannot blame 9A, cannot blame any sort of delay on the court, cannot blame Berkshire Wind. Yes,
All
Your
that being so, I mean, there's a long policy of sort of strictly construing the lien statute. But a lot of that has to do with certainty of title, and that's really not at issue here because there's a bond in place. Is there anything that requires some policy rationale that requires the same sort of strictness, and cutting your corners squarely with the bond portion of the statute as there was with respect to the lien portion of it?
Well, the cases that we cite, Your Honor, say that all the deadlines and especially the mechanics lien law should be strictly construed, and it seems to be pervasive under the entirety of Chapter 254, not just Section 2, not just Section 4, not just Section 14. It seems to be the whole thing. The other prevailing line of cases is that you construe Chapter 254 against the party asserting the lien. So here you would construe it against NES, and so you'd give every benefit of the doubt to Maine Drilling. And remember, it went Berkshire Wind, Maine Drilling, McManus. So the contract with NES was with McManus, the first tier sub, who didn't evidently pay NES, and that's why we're here. So to say that you should give a different standard because there's a bond in place, I think it's really with respect, the whole reason of the mechanics lien law was to make sure that folks got paid, but the right folks did the paying as well. And so here, there's no allegation that Maine Drilling did anything wrong as far as payment. It's NES saying that McManus didn't pay them.
But the consequence here, if you win, the landowner no longer has a lien because the landowner put the bond in, correct?
Correct.
So NES can't go against the landowner.
Correct.
And now, if you win, NES will no longer be able to collect on the bond.
Correct.
So they would have to collect essentially against McManus.
They would, yes.
So that would be their only recourse.
Well, they have a legal malpractice action.
That's been suggested, Your Honor, yes. There's a deadline missed in this case, is essentially what we're saying. So, and there are a couple of issues that were waved down below.
Going back to Justice Lang's question, why are we sparing the bondholder from doing what the bond is supposed to do?
Because the deadline was missed, Your Honor, like a statute of limitations. It was not brought within the 90 days, and so then
But of course, the bondholder had notice within the 90 days that they were commencing the action.
The bondholder knew, certainly, and before that 90 days, my client was contacting the bondholder to get the bond in place. So there's no argument that people knew this was going on, but that still doesn't, on a statute, on a lien and a bond that's created by statute, that's strictly construed and strictly construed against the one who's trying to enforce the lien, it still doesn't give the leeway in order to not commence the action within that period of time. You know, even insurance companies have rights, Your Honor, and I would suggest that, you know, in this case, that, you know, that the action was not brought within the proper period of time.
Counsel, thank you.
Thank you.
Thank you.
If it please the court, I'm Peter Davis. You'll excuse me, I'm very nervous. I've never appeared before this court.
Oh, relax, please.
I'm trying to, but I was privileged to sit with my dad in the 60s and 70s. I'm sorry. I quote in my brief Justice Hennessy. Turns out he was my law school procedure professor, as was Judge Liakis, Chief Justice Liakis, my evidence professor. I only say this because I'm old. I'm over the hill, and I apologize for that. But
So are we all.
as Judge Hennessy said, the purpose of the lien is to provide security, and security for someone who enhances the value of real estate. And there's another policy, it's not stated so often, but policy that a man who improves real estate ought to be paid. And so we have Chapter 254, which sets forth a remedy for an unpaid person such as NES. But what Chapter 254 does is it sets up matters of security. Now, as Justice Hennessy says, the security is the lien. Well, the lien isn't really the security, it's the land that the owner owns, which is the security. A lien in and of itself, you can't take down to the bank and spend it, but we have provisions in Chapter 254 for disposing of the land and using the proceeds to pay. Another matter of security is the Section 12 bond, which the landowner gets at the beginning, just so the no liens will come up. And the third matter of security is the Section 14 bond, which is the bond we have in this case. And there are, in Chapter 254, there's all manner of rules and things what you have to do. And there's essentially the two big rules is Section 5, which is enforcement of the lien, and Section 11, which is an action to enforce a lien. And there are certain rules set forth in there, as there are rules set forth in Section 14. But not everything is set forth. For instance, nowhere in the statute does it tell us what parties are appropriate. So what we have to do is we have to look at due process. We have to look at Superior Court rules. We have to look at rules of civil procedure. We have to look at all sorts of other rules to tell us what to do in a case like this. Now, clearly, due process requires the appropriate party to be the person whose money is going to be at risk at the end of the day. And at the beginning, before anything else happens, that's Berkshire Land. They're the landowner, so it's their land which is at risk. The record doesn't tell us who filed the bond. Counsel says, well, it was filed by Maine Drilling, but he also tells us that Berkshire Land required it to be done. Well, that's not in the record. And Section 14 does, in fact, say a person in interest may file this. Well, I don't believe that Maine Drilling is a person in interest. And then it talks about all sorts of other things as to what we do. But again, it doesn't tell us everything.
But it does say you need to commence an action within 90 days.
Yes, and we did without question, and counsel admitted this, we did commence an action to reach the security. Now, at some point, the security was substituted, and that's why I proceeded by an amendment. It turns out that when Berkshire Land opposed, and they didn't really oppose the motion to amend, They said in so many words, we just don't care. But we don't want to be in the action anymore, and we therefore want to be out of this. And they say in their so-called opposition that, okay, if you want to amend, but they also have their cross motion to get out of the case. Let's assume that they didn't say that. The statute says when the bond is recorded and the rules for the bond are carried forth, the lien is over. Well, if nothing else happens in that case just sort of sits there. Now, doesn't it make sense that the proponent of the bond, who wants to get out of the case, he no longer wants to be at risk, the proponent of the bond says, here's the bond, in this case, substitute the bond for the security substitute the bond, and again, the bond is not dollars, the bond is a vehicle. Substitute the dollars that are behind the bond for the dollars which are involved in my real estate. And when we do that, due process requires that the parties to the bond, namely Maine Drilling and the surety, be brought in as parties. I was astounded, it doesn't appear anywhere, but I was astounded that this didn't happen forthwith upon me getting a bond. And whether it came from the right person or the wrong person was not really that important. All of a sudden, I went from a case where I'm trying to foreclose on some real estate, and then when we look at the original complaint, it turns out that the real estate is a leasehold interest or some sort of Mount Greylock where they're going to put in some wind power and this and that, and all the difficulties that we have with wind power. But it's not a question of Harry's house that's being improved or something. It's a different thing. So to my mind, when we get this bond, we make life an awful lot simpler. We no longer have to worry about foreclosing on a leasehold interest on which may be some public land, or it's very fuzzy. Fine, we have a bond. And I understand about bonds. Now, Chapter 254, they say, well, it's construed against the claimant. But it's not an anti-claimant statute. I mean, the claimant is, a matter of fact, as Judge Hennessy says, and it's clear. We want to help these claimants out, but if we're going to help them out, they got to follow the rules, which is fine. But again, all I could think of when I saw this suit and this and that, I thought back to 1978 when I filed a brief in the appeals court on the Warren Brothers claim. Well, that was a Section 12 bond, not a Section 14. But the statute was substantially amended in 74, I think it was, and 72 and 73. And the real change in the statute was in the 73 amendment when the availability of mechanics liens were changed from someone who has furnished material or labor or what have you, and it changed to, so then it read, is to furnish or has furnished. And prior to 1974, we never saw any mechanics lien cases because you had to file your notice of contract ahead of time. And it turns out that if I filed a notice of contract, all of a sudden the contract went away. But in 1974, we could file a notice of mechanics lien even though we'd already done some work. Now, this court, there were a lot of amendments since then, and this court had to fight over the completion date morass and this and that. And we finally, I think it was in the 90s, we got the Chapter 254 in its section, the current matter. But the whole matter is the 1974 amendment, 1974 statute, was entitled An Act Expediting Payments to General Contractors and to Subcontractors and Improving the Flow of Funds in the Construction Industry. And it set forth lots of material in there dealing not only with public jobs, but also with private jobs. We're not talking about a public job here, we're talking about a private job. But in all these cases, the legislature was trying to protect the claimant and to make the claimant able to get his money. And I suggest, if Your Honor, please, that the reasonable burden in this case was for the general contractor or whoever it was who was the proponent of this bond saying, let's substitute the bond for the lien and substitute the parties. And at that point, the owner dismissed out of the case. The whole tenor of the case changes, but the plaintiff's proof does not change one iota. He still has to provide his written contract. He has to provide his notice of contract. He has to provide his statement of account. He has to record a copy of the complaint in the registry. All these various rules that are required still have to go forward. It's just a question of, at the end of the day, who pays them? And I suggest, Your Honor, please, that we have commenced an action timely to recover on the security. When someone, and it's unclear if it's the contractor or the owner, causes the bond to be recorded, that changes things a little bit, but it doesn't change the plaintiff's case one iota.
So let me see if I understand this. Let's assume there had been no lawsuit here. Your client was contemplating bringing a lawsuit to enforce the lien, but there had been no lawsuit, and the bond was then substituted and the lien was dissolved. You then brought an action for payment under the bond. You would have to establish all of the predicate facts related to the precise and careful and strict application and attachment of the lien.
As a matter of fact, that's precisely what happened in the Warren Brothers case, even though that was a Section 12 bond. The appeals court...
Because it's no longer a lien, it's still all of the requirements...
Right, all those things. So we go back to the same point, and it's just a question of a matter of timing. And again, when I initiated the 9A procedure, I have it in mind that more likely than not, the landowner is going to say, great, let's allow this thing. The rules say amendments are to be favored unless there's something extraordinary. So I can anticipate when I started doing this that the matter would be amended just as a matter of course. I mean, I could not imagine receiving an opposition. And the opposition that I received was, let me out of the case. And I said, well, let's wait a minute here. If you're out of the case and we don't have an amendment, there's a plaintiff, but there's no defendant. I said, that maybe it works, but it just doesn't work as I anticipated. And there's no question about it. I think at the hearing on the motion to amend, I have no problem with them being out of the case. But that's tomorrow's problem. That's not today's problem. Today's problem is amending this thing. And there's not an awful lot more I can say here. I think that I have complied, and my client has complied, with the reasonableness of it. There is a suit in place to recover on the security. And whether the security is being changed from one form to another really shouldn't make a difference. It's a matter more of form than of substance. Nothing else I can say. Thank you, Your Honor.
Thank you, counsel.